Good afternoon, sir. Welcome back.
Okay, thank you. Tell me, Chanchal, what more has to be discussed in that topic? Because now, I think, so far as I am concerned, most of the things I have mentioned. But I would be actually uh, interested in knowing your doubts and your solving your problems and questions.
Sir, first of all, we should start with the lecture, Dilemma of Common Law in Tourism, and thereafter questions will be addressed.
So the same thing should I repeat, or do you want something different?
Sir, the participants, I would also request you how common law, when was imposed or received or implanted, uh, this affected Indian practices in terms of law or soft law, whatever we call it. We cannot call it positive law at that time. So something about that, sir.
Common law and civil law system, or you want to about common law?
Interaction and its impact. Because if we take example criminal law or family law, there were many branches within the community which anything that applied or even commercial law, they had local practices. Very often it is dubbed as convention or custom. The dispute settlements used to happen in informal administrative setup or panchayats or villages. So how British system, British common law, that was a political expediency for them and to temper or to impose common law in different ways or in different stages. So how did it affect Indian pluralistic culture of legal practice? That's the question, sir.
Okay. If I have understood you correctly, you are primarily asking me to say something on the nature of common law and civil law systems. Or you want a very specific question that you have in mind, because it's not clear to me yet what exactly you want me to explain.
Sir, actually, sir is asking that the common law, India had different system in the sense that villages had eldest community of panchayat, national guilds, etc. So once communist legal in India, British started to impose their own normative legal system. So what kind of common law system went over Indian legal system when British came?
Yes, yes. Now, British actually, as you might be knowing from history, initially they sought the permission of the Mughal emperor that they should be allowed to be within their establishment. They should be allowed to be uh, to apply their own law. That is, whatever common law or whatever it was. But slowly they expanded outside also. First, and particularly they, of course, from Bombay they went to Madras. Initially, actually, it was somewhere in Goa, Damandu. It was there that actually Portuguese had come first. The English came later, but Portuguese actually came only for trade purpose and did not actually establish a system here, or did not have the program of establishing a system. But so far as British were concerned, they actually took a route which was based on some sort of deception. Deception in the sense that they took the permission that we should be allowed to use our own law in respect of our own people. In the establishment which we have. So the ruler Jahangir perhaps was there at that time. So he said, no problem. So you can apply your own law to yourself. But of course, Indians will not be affected by that. But then slowly as the scope of, and then they bought these three villages in near Calcutta uh, uh, and made a sort of uh, place and also established a port there, and then brought army also there, and nobody actually objected at that time. And when the objections came from the uh, Mughal rulers or Mughal Nawabs, not rulers, Nawabs, then Mir Jafar and others actually they were fleeced by the English people, and as a result of that, they in a way, yeah, he betrayed so far as Indian cause was concerned, and right was given to them to administer this area. And therefore, everybody who lived in that area, he was subjected to the British law or common law in country. And uh, then later on, means when 1772 scheme made by uh, Hastings, Warren Hastings, in that he made the rule that this territory which is under the British, uh, uh, they acquired actually Diwani rights so far as after Plassey war, and they became Diwan, and Diwan was the actually most important, one of the most important uh, mm, office in Mughal period, because he had control over money and other matters. So they said that so far as this Diwani is concerned, which now belongs to us after the Plassey war, so that should be actually uh, 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 there should be applied to, so far as British people are concerned, to them British law. But so far as the local people are concerned, to Hindus it would be Hindu law which will be applied, and to Muslims the Muslim law, but only in specified categories, not in all categories. And therefore, thus started the concept of courts, but the courts were being headed by British judges. And as a result of that, their interpretations of common law system, they influence the decisions of the judges, and the arguments or whatever which they gave in support of their uh, judgments, they were actually uh, influenced by the English legal system. Wherever uh, law was not there, specifically Hindu law and Muslim law, there actually they started applying English law. And later on, when the Supreme Court was established in 1775, actually Supreme Court was given jurisdiction with respect to not only Calcutta but even beyond. And so far as Calcutta was concerned, definitely whether it was a territorial jurisdiction of the Supreme Court. Therefore, anybody who is living in that territorial area, he will be subject to English law, because the Supreme Court will apply English law. And as a result of that, actually, this what is that famous case that was decided, and to that Brahmin, what was नाम बताओ भाई केस का Eh?
Yes, sir.
Oh, it,
So, second question is related to uh, interpretation by Pandits and Maulvi, as British relied upon interpretation by Pandits and Maulvi, and that is how law of Gentus was developed under the leadership of Warren Hastings. So, how that particular process changed the character of law from the perspective of British? They ignored the
ah,
civil practices of India, and they applied their own sense of law over Indian concepts.
no, this Gentoo law, which was made by uh, Cook or someone, I don't remember the name now. Uh, and similarly, so far as Islamic law was concerned, that was made applicable to Muslims. Uh, uh, so, Hellhead, Hellhead's book, and that uh, uh, Hindu law, the collection of Hindu law by that Indian, not Indian, by was it Colebrook or someone? Now I don't remember the name, but he made the book on Hindu law, and they interpreted it in the same way as they could understand, because it was written in Sanskrit and in, local languages, and therefore, on the basis of the Sanskrit texts, they translated it and made the basis for decisions to be given in all matters with respect to Indians also. Uh, by reading these books, the judges, English judges, could apply the law to Hindus, and similarly also the law to Muslims in Islamic matters. This is how it did. And if the parties are of two religions, then in that case the defendant actually defendant's law actually had to be followed. So if it is a case between a Hindu and Muslim, then the Islamic law will be followed and not the Hindu law. And this way, they uh, slowly they develop their hold on local people, and then so far as Calcutta is concerned, the territory of Calcutta, the whole of it was given in the 1775 that establishment of the Supreme Court in Calcutta, and that Supreme Court applied entirely English law uh, to whomsoever was within the territory of Calcutta, whether Muslim or Hindu or anyone, he would be subjected to British law. As a result of that, uh, that Brahmin, sorry for forgetting names of अब तुम लोग बताते नहीं हो नाम, Nand Kumar's case. So far as Nand Kumar was concerned, he was a Brahmin, and of course he carried out business in Calcutta, but he was not actually resident of Calcutta, but they treated him as a resident of Calcutta because maybe the other party was part of Calcutta territory. And then in that case, to Raja Nand Kumar, they applied English law, and according to English law, within few days, they decided that he should be hanged because he had done some forgery in relation to a in relation to some hundi or something, in which he entered a wrong figure, and as a result of that, he deserved to be given death sentence. This kind of provisions were introduced because in England they applied, and therefore, for trade purposes, it is very necessary that the concerned law should be applied, and nobody should be actually uh, 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 forging the documents. So forgery, even under the IPC, was a very heinous offense. So it is this way that the common law slowly was introduced, and then the jurisdiction of the Supreme Court was applied even beyond. Although, of course, there were Sadar Diwani and Sadar Diwani and Sadar.
Nizamat.
Sadar Nizamat Adalat. So, yes, thank you. So Sadar Diwani and Sadar Nizamat Adalats were there in Bengal, and actually the cases will go to these, but these Sadar Diwani and Sadar Nizamat Adalat also, they were headed by uh, English judges. Earlier, they used to be Muslim judges or Hindu judges, but not the English judges. But now they headed all these courts with English judges, and as a result of that, English laws continued to percolate into Indian legal system, and in the course of time, it actually replaced the Indian legal system, and their own legal system actually was made the law of the state or law of the country. So this is how common law actually uh, made applicable. Later on, the Supreme Courts were established at Bombay and Madras also, and they also did the same thing. As a result of that, the English law acquired a prominence so far as the country was concerned, in spite of the fact that Rajanand Kumar's uh, murder or decision to hang him by the Supreme Court created both animosity and fear among the Hindus and persons who were residents of that area, because this kind of punishments were not known so far as Hindu legal system or even the Islamic legal system are concerned. So this is how slowly then uh, uh, as more and more territories were coming into the occupation or uh, were being won by Britishers. Then in those territories, they started applying the English law to all persons, irrespective of their religion or anything. And that law was basically British law and not the Indian law or Islamic law or Hindu law as it prevailed previously or earlier. Now, so this is how it started developing. Then, towards the end of the 18th century, already power was given to the local administrative bodies. Warren Hastings had already been made as the Governor General uh, or just Governor at that time, and then he was also given power to make laws under the Regulating Act of 1772. He was also given the power to make laws. So he started issuing regulations and other things, which later on by Cornwallis were put together and became Cornwallis Code. So this is how the common law became applicable not only to uh, Calcutta or to Madras or Bombay, but all territories which came under the occupation of uh, British people. Now, through threat and through war, they won more and more territories. As a result of that, the entire country uh, came under their sovereignty. The local rulers also entered into kind of agreements with the Britishers, and as a result of that, they were not being interfered in some matters, but there was interference in other matters. So far as the local rulers were concerned, they continued their own law, applicable their own law, but the other territories which had been won by the Britishers, by particularly after 1857 war between Indians and Britishers, and they won it at the end. As a result of that, then later on, Queen Victoria in 1858 made India as uh, a territory of uh, British Empire, and as a result of that, now naturally, the uh, British laws were made applicable in the whole of area, and nobody could question it. In some matters, so far as local rulers were concerned, they were given freedom to handle things according to their own norms, but that was settled through territory, through negotiations or through uh, those documents which were written in that regard. So that is how, when we got independence, there were Indian states and the rest of the territory. Indian states were uh, sort of independent states, and so far as the territory under Britishers were concerned, that was subject to central government, and therefore uh, the rulers could apply their own law so far as their areas were concerned, and the rest of the area was covered by Britishers. And so it is in this way that by the time the Britishers left in 1947, by that time we had become fully familiar so far as the common law system was concerned, because judges, even Indian judges who were being appointed to the courts, they were also trained in English law. As a result of that, the English law, common law, became the law of the country, and this happened everywhere the Britishers went. This is again remarkable that wherever Britishers came or went, uh, there they imposed the common law system, and as a result of that, common law system actually prevails in all those areas, and maybe in a vaster area than the area covered by all other European countries. Therefore, British law became uh, a normal thing for after we made the constitution and provided for the appointment of judges, etc. Of course, they had to work according to the constitution, but at the same time, they were familiar only to follow the common law practices and procedures. Therefore, they followed that. Now, this common law actually was never written. If it was written only in the form of cases and not otherwise. So there was no practice of writing laws in advance, rather determining laws through judicial decisions. And that is why uh, it is also called as common law, that is law common to all people, irrespective of exclusion of anyone from that. So this is how, so far as common law is concerned, wait. So far as other European countries were concerned, they actually applied Roman law and not the common law. And Roman law was perhaps the most ancient legal system in Europe, uh, and it of course, from Rome it is spread almost in not only in Western Italy and other parts of the country, but it also went up to where now Russia is. As a result of that civil law system, it is called a civil law system, and civil law system it is called because Justinian has actually consolidated the law, and corpus juris civilis is called the that consolidation into 4 volumes, which gives the law and its application in those 4 volumes, which was read by the other rulers in Europe, and they started following those practices. So this is how civil law became the system of, or Roman law became the system of these countries. Now the uh, major distinction between common law and civil law is that civil law is book-based, that its principles were laid down by King or Emperor Justinian in the 6th century, because he was the last emperor of Roman Empire. And the only thing he did was that he collected the law together and put into this what is called as corpus juris civilis. Uh, uh, so it shows that it is basically a civil law and not not a criminal law. And so basically it was civil law, and civil law actually, so far as criminal law is concerned, local practices were given uh, freedom that people may apply their own law. But so far as civil law is concerned, this corpus juris civilis law, which was Roman law, and because of which Romans acquired such a fame in whole of Europe, including England at one time. But so far as England is concerned, it was not influenced by much by, because Romans went there, but they did not occupy that territory, and the as a result of that, already so far as common law is concerned, they were developing that common law, and historically may uh, be that by the time the Romans went there, already some conception of common law had developed in England, and that is law which is common to all people in England. And as a result of that, and this law was based on judicial decisions. It was not based on writings of the codes, as Justinian did uh, in Rome. So this became the common law system, and that is how the common law system remains. This is what uh, Dr. Conrad used to say, that even though uh, I am a civil law person, yet I have learnt about some qualities in common law which don't exist so far as civil law is concerned. And uh, what is common law? The power to determine what is common law is given to the judges, and therefore whatever the judges decide in their decisions, that becomes the common law applicable to all people, though it is a particular case to which it applies, but it will apply to all people because that is the law. And that is how the common law actually became important so far as England is concerned. And the idea of superiority of common law over civil law system was that it was not dependent upon legislation, that there is a law made by parliament and that law has to be interpreted and applied. It was actually in the form of judicial decisions, and therefore, whenever matters arise which have not arisen before, the British judges has had the freedom to say that common law requires this and this. And as a result of that, you would remember that not dissolution but prorogation of British Parliament made by Johnson, the outgoing Prime Minister of England, and it was challenged by the speaker or by others that this is unfair on his part, that after holding a meeting only for one day, he has prorogued the House. As a result of that, only when next session will take place, then only it will be assembled. But only 2 or 3 days had happened for that session, and which was considered to be a bad practice also, or bad power to the Prime Minister. And the Supreme Court of England, now it is Supreme Court, earlier it was House of Lords, the Supreme Court of England unanimously, through a lady judge, actually held that prorogation is unconstitutional, contrary to common law. And what is common law? Actually, nobody knows what is common law until the judges decide that this is the common law. So this is what, therefore, quite often there are critical writings against the American judges, including, for example, the recent case Roe versus Wade in respect of abortions, which was made long time back by a Chief Justice who was very progressive. And now, as the conservative judges started coming to the Supreme Court, they got the opportunity to overrule that decision. Although, so it is actually a restriction of women. It is not a restriction on anyone else except the lady who wants to get rid of her pregnancy. She can't do that. Or if they would do it, they would do it at their own expense. The state has no obligation to help them in any manner so far as finances are concerned. The result would be that the poor people will not be able to pay to the doctors, and they may have to have unwanted children. So this is how common law system actually, the judges are as powerful, though of course there is a written constitution, therefore they have to give justifications under that constitution. But those justifications also are justifications made by the judges themselves, though of course they are made after due discussion. But due discussion in Supreme Court of United States is 45 minutes to each party to present their case, and that's all. So the case is decided only on the basis of those arguments in 45 minutes, and nothing more. So the law may be overturned any moment. But at the same time, this quality of common law was established in all countries wherever the Britishers went. So Canada, Australia, apart from America, of course, and also Singapore, India, and many other countries, they became part of it. Civil law system, the persons from Europe, this Western Europe or on the mainland, they did not lay down any such principle that only English law will be applied or their own law will be applied in their territories. Some elements of that were learnt by people in countries like Indonesia and some others, but basically they left the law to be applied according to the customary practices of the local people. Now, India did not have that opportunity, and as a result of that, common law system was established. And this is what in the previous class we said, that the judges have certain inherent powers which they may exercise as the time arises. It is not that they will exercise haphazardly. If they exercise haphazardly, then it will lose its character, and the kind of importance which is given to common law, that would be lost. And that is what Dieter Conrad used to say, that although I am a German and I love German law in number of respects, but at the same time there are some qualities of common law which don't exist so far as the civil law system is concerned. And that quality is that the judges are the final lawmakers. It is they who would tell as to what the law is, and that is that he thought that perhaps for that no legislation is to be searched, no constitutional provision has to be searched, but on their own understanding the judges may give the decision, and this is what the court did in Roe versus Wade, which, of course, when I was a student in Columbia University, our professor, because the case was recent at that time, our professor actually, Professor Lusky, he discussed this case in detail, and the so far as the Chief Justice was concerned, because the cases were being brought before the Supreme Court every time, and by the time the Supreme Court will uh, decide to hear it, the woman actually gave birth to the child. And so it was never decided. The reason being that it has become a moot question. Now the pregnancy has terminated, and so no question of deciding this matter. But this Chief Justice Warren said, in this manner we will never be able to decide this issue, because every time by the time the Supreme Court would come to hear the case, the child will be born, and this matter will never be decided. But this has been reversed now, as you know it, and as a result of that, the power of the court is established irrespective of. So every state has to make a law for termination of pregnancy, but automatically there is no fundamental right so far as the women are concerned. It is not part of due process of law, and therefore it is excluded. So the criticism of the judgment is also for that reason. हाँ चंचल और बताओ क्या करना
है? Very nice explanation, and that it was because of the particular culture and particular judicial system British had, and then when they got power in India, economic, in the first 100th century, basically in this country, 100 years, and later as a political power, it happened like that. There are alternative narratives. Development of or imposition of common law, and the alternative can be read, alternative explanation or narrative in Ranjit, that is quite different. So I'm going to raise another question, sir. That is the fundamental supposition James, okay, Mill or Anthem or similar people had the mind behind the administrators, British administrators, was that India had no legal system or
India had no legal system. Okay.
uh, that was the main fundamental basis on which Britishers proceeded in imposing or the Indian farmers classes, the leader classes, received it that they vertically might have medieval or ancient, maybe medieval or irrational. There are certain developments in last 30 or 40 years. For example, in Australia, so compared to India, societies like India, Australian territory had little social or economic or sort of development. The British reached there and colonized it, and they are aborigines. So in the recent, we can call it recent, Millirapam case, two subsequent cases, 72, that is popularly known as Mabo 1, and the 1992 case called Mabo 2. In fact, High Court of Australia has acceded to the claim that Aboriginals did have a social order, and therefore social order can be imagined without a fundamental or having fundamental sort of law or legal rules. So, if related to certain claim to lands by clans of Aboriginals still living there in Australia, has, in principle, agreed that they had a social order and therefore they had a legal system. They may forward claims to those coastal areas on the basis of the earlier legal system. So that opens a very large question that is relevant to legal pluralism also. So what is your take on this developments?
My take on this is sixth schedule of the Constitution of India, that tribals are given power to decide their matters by themselves. The ordinary courts don't have the jurisdiction in those matters. So, that has been taken into consideration in the making of the Constitution also.
That is schedule fifth.
Sixth.
Schedule.
Sixth schedule of the Constitution. Yes.
371 onwards. Other parts or territories or communities for whom such provisions constitution do not imagine. That is the majority.
Those earlier constitutions, because they were comparatively less applied and they did not have a stable life. This 1919 constitution failed immediately after being made, and similarly 1935 also did not work because came the struggle for independence, and British also had decided that now India should be actually divided into India and Pakistan. So as a result of that, many of those things. So so far as the this is also a good example that so far as Pakistan is concerned, it applies in most of the matters common law system, but it also applies their religious system, Quranic system, and therefore there is a Supreme Court to interpret Quran also. And in addition to the Supreme Court, which decides matters relating to the Constitution and other laws. So in any matter, questions may be raised that it is against Islam, and the Islamic court will decide that matter, and the ordinary courts would be bound by that decision, including the Supreme Court of Pakistan, which decides those other matters. So the religious court is a separate court because they also hold Quran as a law and they apply it. You may also apply Manu's code if you want.
Sir, Richard Abel wrote a wonderful paper that is comparative analysis of dispute institutions in society. So, dispute institutions are very significant to understand the character of society. In that context, ancient Indian societies were primarily based upon panchayat system or informal system and
Yes,
normal law.
yes,
But
yes.
they brought official courts, official system of law. So
Yeah.
how the character of dispute institution completely changed from informal, non-state legal system to
No.
a state
Yeah,
oriented.
a law has been made already to establishing panchayats all over the country, and at some the result of that law is that they will slowly apply it. But I don't think that any state has applied that law so far. So it also depends upon how much curious you are to apply a particular system. So far as uh, Islam people are concerned, uh, they will kill themselves, they will kill others also. If anybody decides against Quran. And so far as meaning of Quran is concerned, that Islamic court is the highest court to decide what is the meaning of a particular ayat in Quran. We for us there would be problem. So many problems. I am not sure whether Manu was applied all over the country. Uh, so maybe it was applicable only in some part of the country uh, and was not applicable in other parts of the country. Hindu law itself, for example, has many schools, and these schools actually have different law for Hindus also. So this is how the positions has been different. It is another matter that now Hindu Marriage Act and in the Succession Act and guardianship and other things, they have in a way codified the law and uniformly applies, but it doesn't apply to uh, persons of Islamic law, or it also doesn't apply to customary practices in different parts of the country. So maybe some 50% or 60% or 70% of the people are governed by those legislation, and not all the people, because those people have different customary practices, and customary practices are excluded in those laws also. Specifically, the customary practices of the tribal people and other people also will have to be given importance over and above the law.
Yes, sir. And sir, Henry made in village community of East and West described that in Indian villages, right consciousness was absent. The people were generally accepting the authority of elders and without questioning their decision-making process. But ultimately, Britishers brought a new consciousness in our society that
Mm.
anybody can challenge the authority of even elders. And that is
Mm.
how whole culture of non-legal system changed. So do you agree with the analysis of Henry Maine, sir?
Yeah, long time I have not read Henry Maine, uh, uh, and I didn't get exactly the question you raised. Don't repeat it in such a long speech. Just tell me what exactly you want to know from me
Yes,
about
sir.
Henry Maine.
Actually, sir, generally we understand Indian society has been duty-oriented society. And in duty-oriented society, you accept the authority of elders. My parents are saying something, I will not question it. But when
Mm.
it comes to the consciousness of right, that it is my
Yeah.
right against someone, then I don't accept the ready-made authority of any person, and I start questioning everything. So this kind of culture was absent in Indian society. It is British who, with their legal system, brought this kind of culture in India. So do you agree?
So that is true that so far as uh, Britain is concerned or the common law system is concerned, law applies to everyone as soon as the child is of 18 years of age. He is free not to abide by the norms which the family has, and freely they can live their life according to their freedom as given in the law generally. So this is not only in England, but it is also all over Europe also. So our children, even when they have their own grandchildren also, uh, they remain loyal to their parents, and maybe if the parents are not allowing something to do, they may not do with respect to the family. This is generally happens. But these are matters which are not legal. These are actually customary practices. We follow that, and perhaps there is no harm if you want to have a joint family. Then you have to listen to each other. Otherwise, it won't be possible to run a joint family.
Yes. Now I would like to invite questions from the participants. Yes, Neha.
So the subordinate position of women, we
Mm,
see has started with the advent of common law. Because
mm,
before that, we see the position of women was better off in India, and
mm,
mother and various forms of women were worshipped. So,
mm.
do you think, do you agree with the proposition that I made, sir, that the position of women was subordinated with the advent of the common law,
Common-
and now we have a vestige of that colonial law that we see in today's laws also, that position continues to
uh,
be.
Now it is subject to whatever laws we have at the moment, because uh, Manu's system or any system that existed before is not directly applicable in all matters. And even in matters which have been covered by those four legislations in respect of Hindu law. And so, therefore, the same law doesn't apply anymore. Even joint family system, which was very traditional system, that has also been affected now with the but it may be justified. I will not say that it is not just and fair that the uh, girls should also have a share in the property of their parents. Uh, that is totally justified, but it's very different from the idea of joint family, because family perhaps may not remain joint. Uh, if the daughter comes back with her husband and children and brothers and sisters, they will have to make a different joint family. That is so. By and large, in spite of the fact that there is law, and now the rights of the daughters are also recognized, by and large, the position is that daughters normally don't claim, and but if they claim, there are problems in the family, and therefore it's not a question of law. Law has been changed, and therefore, if one wants to go to court on these issues, one can go.
Any other question? Yes.
Sir, my question was not so much on the front of personal laws, but more on the front of criminal laws, sir. Like, for instance, the law of adultery, or the law of unnatural offences, or even marital rape. All of these laws have origin with the colonial vestiges. And we see that the position of women here is subordinated, which was not earlier the case in Indian laws or the ancient medieval laws.
I didn't get exactly the question. Can you just let me know in short?
Yes, sir. She is saying that culturally, India always respected women, but after the coming of British, they brought new kind of consciousness in our society. And particularly the IPC, we find so many sections which reflects Victorian morality. So it was the reflection of Victorian morality which changed Indian culture. Indian culture always respected women.
हाँ, ये सब कहानियाँ हैं। असलियत में कभी ऐसा नहीं हुआ कि बहुत रेस्पेक्ट दी हो। तुम अपनी वाइफ को लेकर बड़ौदा से यहाँ आ गए, उसकी नौकरी छुड़ा के, तो ये सब होता है फैमिली में। तो अब या तो फैमिली तोड़ दो या फैमिली इस तरह से रखो। तो ये क्वेश्चंस हैं which are more customary than legal practices.
Yes. Okay.
So that is why normally daughters don't make a claim in the joint family. Let brothers have it, and they have their own family, and their husbands also have share and all that. So I'm not saying that in any case it is not relevant, but in some cases, because joint family may be only of daughters also, and in that case, one or two daughters have to come back to run the house, and that is possible always.
And sir, don't you think that common law system brought advocatory culture in India? Because Indian culture was quite inclusionist with resolution of disputes instead of adjudication of disputes. So character of adjudication has changed.
Some certainty in law is necessary, and therefore that certainty, whether it existed before the application of British law, we are not quite sure, because there were different schools of Hindu law in different parts of the country, and therefore different laws were applicable in different parts of the country to different people, and therefore if we want to live in the modern age and as a unified country. I'm not saying that it is not federal, but unified country. Then in that case, you will have to create laws which are applicable throughout India. The states may make their own laws, no doubt about it, but there is a responsibility on federal government that laws must be made which are applicable throughout the country.
Okay, thank you, sir. Now, in concluding remark, Dr. Navitya ma'am will propose a vote of thanks.
थैंक यू भैया, मैंने अभी खाना भी नहीं खाया। मैंने मन का अभी खाना भी नहीं खाया है, तो जल्दी छुट्टी करो मेरी।
Thank you so much for your valuable insight. We here at HPNLU are blessed to have you here, and hope that you recuperate soon, really soon, and be here with us physically to give us more insight, which in kind of like the age and experience and your stature can provide us. Thank you so much. We are highly indebted, sir.
Thank you for giving me this opportunity to talk to you, particularly to Chanchal and also Mrityunjay now. So they have compelled me to become part of it, and this is a pleasure. So I have to accept my students' requests. So that is how I take it. I don't know whether Mrityunjay was my student. No, I had retired by that time.
Yes, sir. Yes, sir.
But,
Now I understand, sir. I have read your piece.
but it doesn't matter. There are many others. Okay.
Okay, sir. Thank you,
So
sir. Thank you.
thank you very much for giving this opportunity. It is nice to talk to you, and
Yes, sir.
we could speak substantially on matters, different matters.
Yes, sir.
Okay.
Yes.
Thank you.
Thank you, sir.